to remove that bright line with this. Good, bad, or like I said, I'm not actually even giving an opinion on that because I understand why there's some interest in doing that. But I'm saying that when we do that, we open every consumer up to not knowing who can and cannot give them legal advice and what can and cannot be done. And that I think has some inherent dangers.
Yeah. Do you think that could be solved? I mean, I'm speculating with this, and you would be too in answering, but do you think it could be solved by some wide publicity about the new category, the new name of the professional? Could be public service announcements too.
You know, can it be solved? No, it will not be solved by that. Can it be mitigated? Probably. I mean, it's a lawyer answer, sorry, but you know, it can be mitigated, but what you're expecting our citizens to do then is to have the sophistication to know what a lawyer is, what a licensed paraprofessional is, and what an unlicensed, you know, practitioner of law is, at least at some level. And you're asking that they see that information, absorb that information, and can utilize it at a time when, as we all know, people come to lawyers not because they're having a great day. You know, I once had a law professor who told me if somebody's talking to you, they're having a really, really crappy day. Okay. And so we're asking people who are often in crisis or trauma to make these distinctions. And these are some of this, even with the, you know, the smaller amount of things that these people can help them with, can really be life-changing. So immigration consultants, these people go from maybe even being under the radar, no one knows about them, to having an arrest warrant out for their deportation.
Occurs to me that the paraprofessionals ought to have a badge. I mean,
yeah, well, I've seen that problem too, but yeah.
Remember,
that's
they will be listed on the State Bar website. We have a few other hands up. So Steve, you want to speak to this?
Sorry, yeah, it's not just that being able to identify the person as a paraprofessional, or, you know, immigration consultants are registered as well. The question really becomes, as Ryan brought up, when they go beyond the scope of that, and the client not knowing or not recognizing that they are going beyond the scope, and that's sort of the issue that we've seen in the immigration consultants and legal document assistants and things like that. It's I have been to a doctor's office, and I've been seen by a doctor, I've been seen by a registered nurse. I don't know what the registered nurse can do that is the practice of medicine that that they should not do. But if there were no registered nurse, I would know that somebody other than the doctor was treating me. I think that's sort of where Ryan's going with that. And those are the problems that we've seen in those areas. And we do see those where the legal document assistant starts choosing the form that they're going to fill out. That's not within the scope of the legal documents assistant's certification. They can really just be that scribe. And if they're choosing the form, in many cases, that is the unauthorized practice of law because they're choosing a strategy.
Yeah. Okay, Sharon, and then we have an attendee with a hand up as well. Go ahead, Sharon.
Hi, Ms. Jordan. This has been really eye-opening and clear testimony, and it's a lot for this working group to think about as we proceed. You've really highlighted the lack of resources. It's pretty unbelievable to me that in LA County, such a large county, it's only you that's, you know, with limited resources that's prosecuting these cases. And you're only touching the tip of the iceberg. So like the most egregious criminal cases. So I guess I'm trying to understand, your office has limited resources to prosecute these criminal cases. The State Bar cannot investigate criminal cases. Can you tease out, I guess, the types of scenarios or cases that fall between the jurisdictions? Like, for example, what happens to criminal cases of purposeful misconduct and other types of cases that don't fall under your jurisdiction and don't make it to Gus?
Well, so typically they're actually going to make it to Gus and not to me. I mean, Gus, disagree with me if you think I'm wrong, but that, Gus is going to get the complaints. And, they might not find that there's misconduct, or they might not find that there's misconduct, and he'll hopefully correct me if I'm wrong, that they're not going to find misconduct that rises to the level of a state bar action. If it doesn't rise to the level of a state bar action, it's definitely not going to rise to the criminal action. So, it's going to be one or two people who have a complaint, and, we can't prove that this person mishandled it. But the other thing's going to be things like threats, right? So like I was saying, people not reporting at all because of fear or intimidation. The other thing is that Gus might be able to do something, or might be able to disbar the person, whether they're a paraprofessional or a lawyer, but that's not going to necessarily restore the client or restore their ability to get legal assistance. And as we all know, time is of the essence. It's like the first thing we learn in law school. So when these people do these things, they are going to, very much hurt our client. The real problem area is we're going to have licensed paraprofessionals. So like Leah said, you can look them up. Great. By taking, my concern is by taking away that bright line rule, we might have somebody walk in and say, well, you're not a lawyer. And the person's like, no, but it's okay because non-lawyers are allowed to practice. And so we're then asking the client to take the next step and understand that, okay, well, now I should look this person up. I mean, a lot of people don't do that with their lawyers, right? Or the people who are disciplined would not be able to practice as well as they do, right? So we're adding another hurdle. And that's always a concern, I think, for everyone on this board, that we want them to have access, but we also don't want them to be more vulnerable. And my point is, by removing that bright line, Gus can't prosecute them and take away their license if they're not licensed to begin with. I can only prosecute the worst of the worst of people who are unlicensed. And right now, if you're unlicensed, I can't do much to you, no matter how much you do, and no matter how many people you do, hurt, and how many times you do it. And so there's some real holes that are going to get bigger when we remove kind of that initial bright line understanding that most people have of the legal system. And we're going to ask our consumers to be more sophisticated in figuring out what it is that they need to do to protect themselves and make sure they're getting licensed, accurate, and competent legal assistance.
And one more question. You have sat in on many meetings, so you've been listening to what we've been talking about. And I guess going back to the resource question, because inevitably this will open up more UPL, because that's what new systems do. And like you said, there are going to be the people who use this new scheme as a way to practice without becoming a licensed paraprofessional. So do you have other suggestions? And you've already given us some really great suggestions for laws that should be changed, including statute of limitations. But do you have any other suggestions on threshold resources that would be needed?
Well, I do think that, resources and funding for some sort of dedicated criminal investigation, whether it's through the state AG's office, so that the Attorney General has, or Department of Justice has a group that investigates these and then brings them to local prosecutors or to the AG's office, or, grant monies for local prosecuting agencies to hire investigators and lawyers to prosecute these. But I think, resource management is going to be important. And, along with restitution for our victims so that they get paid, money, whether it's a fund that, they have to pay as part of their licensing fee, to support this is vital to make sure that the worst actors are removed from the practice and from the consumer base.
I agree with that. And that is something that we at the State Bar have talked about on many occasions, way back to 2017, 2018. I also, as you may have heard me say, the last time I joined this group was that I have a DA background and spent 20 years in the DA's office, the last 5 managing the consumer protection unit, and several other white collar fraud units. And many of those units were grant funded. And so we had actually proposed some sort of a grant to local DA's offices for investigation and prosecution of this sort of thing, exactly for that reason. We have as Ryan said, we have a great relationship with LA DA's office, and as few resources as they have, LA County has been very active in this space and should be commended for that. The theory is that if we allow funding and have funding for local county offices and city offices where they prosecute these crimes to investigate and prosecute these cases, they will create the resources within their offices to do that. None of these agencies are predisposed to not prosecute these crimes. They all are very eager to take this on. They just don't have the resources. So if we have earmarked funding for this purpose, I think that many of these offices would take it on and take it on aggressively, as LA County has done.
Amos, you had your hand up. Did you intentionally take it down?
Well, I think a lot of the points were covered, but I do want to make it clear. Thank you both for your presentations. I do want to make it clear. I think I was at least one of the people who suggested this joint meeting with the discipline and the regulation subcommittee. And it's because this is an issue both of us are facing. I think for the discipline, probably for licensees or former licensees, and for regulation, it's come up as one of the main primary risk areas of standing up a new class of licensees is, as you, Ms. Jordan, put it, scammers are going to have a field day, or we're going to be opening floodgates. We're going to see increased scammers and predatory practices by non-licensees. And what can we do about that? And so a lot, I think, of what has already been recommended with wish lists or recommendations is what we're looking for, because I do think as part of our work as a working group and for both of these subcommittees, we want to make recommendations to the State Bar. We may want to be making recommendations for new legislation to supplement or to stand up this program. And the question is, what should that look like? Rules of court, disciplinary standards. We talked about bonds, but really that bonds, we are recommending a $100,000 bond for licensees, but that doesn't address the non-licensees, and it doesn't make victims of non-licensees whole at all. So the question is, we've heard additional resources. Already the system is pushed beyond its limits. There's already not enough investigation and enforcement of UPL. And by standing up this new license, we are likely just exacerbating that problem. So the question is, probably that's beyond the State Bar. That's going to need legislation and funding. And the question is how much, where does that go? For the changes to make felony options available, that's going to require statutory changes too. And it sounds like you're recommending that felonies be available for UPL cases that don't have a prior license as well. Is that right? So there's a couple different changes to make felony, have a bigger stick and make felony available in addition to resources. Is that right?
Correct. So right now, if you were licensed and lost your license and you practice law without getting your license renewed, the first time you do it, it's a misdemeanor. After that, it can be filed as a misdemeanor or felony. It's something we call a wobbler in the industry. If you were never licensed, you cannot be prosecuted for felony, no matter how many times you commit the misdemeanor. So bringing the unlicensed people in line with those who have lost their licenses is, I think, a needed fix no matter what, but it's definitely a needed fix if we are going to, if we're going to have a higher level of confusion among consumers about who is licensed and who is not, because it just gives the fraudsters another way to trick them much
And-
more easily.
And that statutory change, Greg, is that on the list now for statutes we may want to suggest changes to? I don't know if we need that statutory reference or we can find it, but that sounds straightforward as a potential legislative fix or change. Funding, obviously, we're talking about that. I do note that in LA, we also have the LA Department of Consumer and Business Affairs, which has supported our office. I'm at the Attorney General's office in the consumer protection section. And there is overlapping jurisdiction, as we've heard, not only the state bar, the DAs, city attorneys, AGs, some maybe county or city investigations, but there's just a lack of funding across the board. There's just not a lot of investigations and prosecutions happening currently, and that's only going to get worse. I wonder for the restitution or fund or some other fund for victims of non-licensees, are there currently any victim restitution funds that could be expanded to include victims of UPL?
So we do have a crime victims fund through the state that does help with actual loss. So for example, if somebody's the victim of a murder, that, you know, they'll help pay for, you know, burial costs. But typically losses like this, purely financial losses, are not going to qualify under that. And I would have to look at the specifics, and we have we have a group, we actually have a unit that does restitution. So if that's a question you all have, if you want to, you know, give me a specific, specific things to ask about that, I can definitely reach out and get you someone who knows that system better than I do, and some very specific ideas of how we could do that.
Great. And last question, and this might be for you, Mr. Hernandez. It has to do with the assumption of practices. In my limited experience with that, we did have an immigration fraud case we did. My understanding is assumption of practice doesn't mean that anybody at the state bar or any licensed attorneys will be taking on those cases and providing legal advice. It means you're going to get their files back and try to get the files back to the victim. So they're still in the lurch unless somebody, unless they can hire an attorney or a paraprofessional. Is that right?
That's correct. And, we don't return 100% of the files because the clients just don't respond. They moved on, the address is stale. They might not be in this country anymore. But those that do come and retrieve their files, they typically go out and retain another attorney. So those people are not necessarily out of the lurch, but you're correct. The state bar does not step into the shoes of their attorney and continue the representation for them. Well, one, I don't think that's allowed by the statute. And two, we would not have the resources to become attorneys for these thousands of people that are affected by this.
Nor would we have the expertise necessarily, right? I mean, it could be that they are in an immigration case or whatever else it is, and we have some people with some immigration experience who are prosecuting attorneys who have committed misconduct in the immigration space, but we can't necessarily take that on to then represent them in immigration court.
Right, but as far as resources for how we're going to regulate this going forward, if there are victims of UPL or there are victims of licensed paraprofessionals that go beyond their license, one remedy might be to provide, an attorney, right, that can take on those cases and actually try to clean up whatever issues there are, I assume, or at least resources for that.
One thing, Amos, that so your question actually brings up something. One of the issues that the consumer protection units across the state are handling are something called PACE loans, which are they're very ugly loans that have caused a lot of fraud around them. But one of the things that the Riverside District Attorney's Office did is they went after one of the financiers of these loans and part of the money that they received in a settlement, they then paid out to public interest law firms to provide legal assistance to those who have been defrauded by those loans, to help them recover their homes or recover. And it was a very synergistic, sorry, I know that's a buzzword, way of solving the problem, because the costs were borne by those who committed or who facilitated the wrongdoing, and gave money to those who could help these people solve the legal problems that it caused. So even though the prosecution occurred, that didn't solve the fact that these people were losing their homes. And so that's, I really like that model. And it's something to consider here, that, you know, having the bad actors pay money into a fund that then can provide, you know, legal assistance through public legal services that are already there. So we're not creating a law firm. And this is me not as a district attorney, this is just me telling you something I've seen. It was a pretty efficient way to get legal services quickly to those who needed them the most. And Sharon, I know you have some background in that.
So we've had a couple of attendees with their hands up for a while. I see Sharon with her hand up. I'm going to go to Sharon and then go to the attendees. I did want to ask if anyone has data to support this, what's being stated, I think, as a fact, that when we add a new class of licensees, we're going to see increased UPL, because that is not the experience out of Washington State. That I don't know that we saw it with LDAs, UDAs, immigration consultants in California. I don't know. I haven't seen that connection. But where I have asked other jurisdictions with paraprofessional programs, they did not experience an increase in UPL. So I just, while we go to other folks with their hands up, would love to see if there's data that anybody has on that. So Sharon, go ahead.
You're muted.
Sorry. Just a quick comment about the PACE loans. I really like that model of providing victims of that scam, that funding, but for all the legal aid organizations that were processing those cases and working with clients, it's not that they got increased funding. So just a commentary that you know, sometimes these systems get taxed, and we really have to be mindful when we're thinking about resources and total cost to systems beyond just standing up a program.
Okay, Kim.
So I have a question. I completely understand, and Leah, that's a great question about how if there is any numbers about the impact, because one thing that I think is I completely agree that it's probably the potential is there for a lot more unlicensed practice and people preying on individuals from that perspective. But the interesting thing about the paraprofessionals is that unlike the attorneys, there's just a statement, you know, you can't practice law, you know, unlicensed. With this, it's going to be very, at least in the beginning, it's very prescriptive as to what these individuals can and can't do. So while there might be more individuals coming in to prey upon individuals, don't you think those cases would be easier to try though? Because it is going to be so specific as to what they can and can't do, and maybe that's where we need to reach out to you when we are writing these sections to say, okay, if you had this case for unlicensed, is this going to cause problems? So I'd love to get your perspective on that, because it is a little bit different than it's just wide open.
So, you know, I don't have those numbers because I don't think anyone tracked it after the Immigration Consultants Act, for example, existed. I am talking about it from 23 years of experience prosecuting crimes and fraud. And my knowledge of that is when something changes, we see an increase in fraud related to that change. So my example of that is we had a change in administration in January. We had a president who said he was going to change the immigration system in January or February. We immediately saw a shift in the fraud, saying that, oh, President Biden has now said you are eligible for immigration, you know, for for getting into this country, give me money, and I will get you immigration under President Biden's new plan. So no, I don't have specific data to that. I don't even know quite how we would know that, get that data. What I have is the anecdotal data that when something changes like this, con artists are very facile. And so they shift their pitch to fit what is going on. And so I have no reason to believe that that they're going to suddenly stop doing that when that's what they've always done. So do I think there will be more fraudsters? Maybe not. I just know that the potential for this change to give rise to a new way for them to to suck people in my experience, is very high. And just like, something as small as literally an election and a change from one party to another causes a huge increase in people being told that now they should pay their money because now they're going to get their citizenship, for example. Now, the other part of your question was, are there things we can write that are going to make it easier for me to prosecute? Well, I've told you some of them, but I'm seriously, my concern is far less about the people who are licensed to do this, because there's always going to be licensed bad actors. We're used to that. We understand that. We know how to deal with that. That's going to increase slightly just because more people are going to be licensed, right? So you're going to, you go from 100,000 licensed people to 400,000 licensed people, and 2% of them are, people that are doing the wrong thing, we're going to have 2%, a relative increase. The issue my concern as a consumer protection lawyer is that when we take away bright line divisions, things get muddy for us. When I've got case law that I have to use about what is the practice of law and what isn't the practice of law, and the courts can't agree, and I'm now asking someone who has never gone to law school to figure that out, that, slippery slope is of concern and needs to be considered when we are talking about resources, problems, and how to solve them. It's not that we're going to get rid of them. It's not that we're going to keep them from happening. It's proactively saying what is going to happen and how do we mitigate. For me, as a prosecutor, that's how I think of it. So I didn't really answer your question, Kimberly, because I'm a lawyer and I don't do that.
Thinking it would be more, easier cases to try, quicker cases than, because it will be so prescriptive as to what they can do that no. Okay.
No, because the Immigration Consultants Act theoretically is the same thing, and those are not easy to try.
Yeah, and I would just like to add that I think you did answer the question, not only Kimberly's question, but also Leah's question about the data, because it might not be data specifically about paraprofessionals because they don't exist yet in the state, but I think we have a lot of experience. Consumer protection attorneys, prosecutors, legal services attorneys have been beating the drum now for months and months that this is one of the biggest concerns about standing up the program. We do have competency concerns, we do have excessive fee concerns, but it's the unauthorized practice of law and predatory practices by non-licensees. So I do think there may be some, I think for licensees, it may be a little bit easier. And one of the pushes of the regulation subcommittee is really wanting to make it clear what paraprofessionals can and can't do with mandatory disclosures or clear bright lines, because the bright lines do help, but they don't help for non-licensees. And the question is, what do we do about that? And again, we may not have a lot of options, but certainly some of the things that have been suggested here about making felony available, making additional resources available, maybe some kind of fund, maybe statute of limitations. I think these are great ideas for us to consider. Thank you.
And just, clarity, I just don't want this to be an unintended consequence of a good thought, which is to expand legal services. you guys will do a good job of making sure that the licensed people are properly trained, properly, handled. It's what is the unintended consequence of allowing this new class on those who are already out there preying on our consumers.
All right, I'm going to open things up to a couple of attendees who've had their hands up. Angela Grijalva. You're able to talk, but you're muted. Go ahead.
Good afternoon. Thank you so much. One of the comments that I'd like clarification on, and one of the things that I encounter as a legal document assistant here in Sacramento, working with the public, is this concept about bright line understanding of the legal system. I think that's like a misstatement within itself. I respectfully say, because that's the whole issue. The public at large doesn't have an understanding of the legal system at all, and that's why they're coming to us in the first place. And so I don't know if I'm proving the point or otherwise, but I do think it's worth stating that, I will take the time to educate my clients and say, what a legal document assistant is, what a paralegal is. And I will explain to them the differences. And because they're frustrated and like, I can't find someone I want help with it. And so I try to take the time to explain it to them. But all of that, even though I'm sitting there and explaining it, they just glaze over, and they just, and I explain to them, and they still call me their paralegal, or some will even call me their attorney, God help me, and I correct them each and every time. But the average consumer is frustrated, and they're burned out at this point, like you're saying, because they've already they're dealing with a stressful situation. They can't take on the complexity, nuances of whatever profession and They don't care. They just want the job done. Now, I agree. As an LDA, I keep my boundaries tight. I say, nope, that's beyond my scope. And what I've learned to do is redirect. Here's an alternative resource. Or what I've learned to do is the courts.ca.gov has amazing resources, and Sacramento Superior Court has great self-help resources. I supplement and I redirect clients to those resources so they can make decisions. But I mean, to say, like you're saying, it's sometimes people with JDs, they have hard times dissecting. I mean, I've had the SAC DA contact me to ask for clarification about our position in our LDAs and what our scope and what we can do and who regulates us and stuff. So I understand how, even the attorneys might be confused, right? You should listen to some of the meetings we have, or the task force has. But, to say there's a bright line understanding, there is none. That's just not a reality in my experience. And I do agree. Typically, our community, the Latino community, undocumented community, they don't report. And I think there needs to be a concerted outreach to the community, and not from just, this big political position, state bar telling you come and report here. That needs to be a grassroots effort, right? From people and community members that they understand and they know and that are safe, right? Because our community constantly hears from a government. There's no trust from the government agency, and they hear this from the government and that from the government. But what their firsthand experience is something entirely different. So if you're going to do outreach, involve grassroots organizations, right? Those of us who are on the ground working with them day in and day out, they see us on a regular basis and they know we're not going to mislead them, right? And that's equity and trust we've built over the years.
Thank you, Angela. I'm sorry, I
that's okay.
Set a time limit, but
no worries.
Hopefully you're done, and that's a great point. Jason, go ahead. Jason Solomon.
Hi, Jason Solomon.
Jason?
Okay, hopefully, can you hear me now?
Yes.
Great. Jason Solomon, Stanford Center on the Legal Profession. I think it's a very useful discussion. I think in terms of the wish list, these seem like great ways to crack down on some of these bad actors. And I hope we really can make these part of the proposal from the Paraprofessional Working Group, particularly, making it a felony for people who are not licensees. So I think that's terrific. I do think, consistent with the last comment, a few things. One, we want to be careful not to overlook. I know the point of this is to talk about bad actors and the small percentage, as the Deputy DA mentioned, of bad actors, but we can't overlook all the great stuff that is likely to come out of this program for precisely the kinds of communities that we're talking about. My center just released a white paper on the program in Washington that indicated that it's had really a surprising amount of success there, particularly in vulnerable communities. We talked to folks in more rural parts of the state where there are largely Spanish-speaking communities, where there are people, these legal technicians who are the equivalent of the paraprofessionals we're talking about, who are serving 90% Spanish-speaking clients, people who couldn't get help any other way. So I just want us not to lose sight of that. Just to support Ms. Grijalva's great point just now about the lack of an existing bright line between a lawyer and non-lawyer, and whether somehow blurring that line is going to increase the chance of bad actors succeeding. I think as all of you have said from the beginning, the reason why we have this opportunity for fraud is because these bad actors are leveraging the fact that a notario in Spanish-speaking countries where these folks come from, notarios are allowed to practice law. That's the key thing, as I understand it, and I think as everyone agrees, that is enabling them to commit this fraud. That's not going to change. The fact that they're introducing this new class of license, that's not going to affect things very much. We still have this basic problem with the notario having one meaning in the home country and a different meaning here. That's why they're able to commit fraud. And I don't think we should put too much weight in the absence of further evidence on introducing this new license class having the ability to do anything else. One other quick point, and I'll wrap up. It would be one thing if we were talking about immigration consultants, right? If we were talking about creating immigration consultants, an area where these bad notarios are already preying on people. And I think the loan modifications that you mentioned should give us pause in introducing something related to that practice area. But when we're talking about other kinds of practice areas, I don't think we should have the same concern. Thanks so much.
Thanks. All right, so we don't have anybody else with their hand up. We've got about 9 minutes. I'm wondering if we can just brainstorm our list of things that this joint subcommittee may want to pursue further. And certainly I can follow up afterwards to get specific statutory statutes that we want to amend. We just want to make sure we have a good comprehensive list. Go ahead, Amos.
Yeah, I mean, I think this has been a wonderful discussion, so thank you. I don't know if going forward, if we want to take it back to separate subcommittees and do it, or do something joint, just logistically, but I do think as far as non-licensees, so I think the regulation of licensees fits better with discipline potentially, and the regulation of non-licensees, if we want to make that distinction, probably is more in the regulation and in the additional statutes we want to propose be included, because a lot of it is beyond what we're doing in terms of rules of court or rules of professional conduct. And so that's really a separate bucket that I think we have the felony issue I would love to include, and the resources and the statute of limitations. I think the harder one is the funding for victims, because I don't know if there's any structure for that. I haven't heard what that might look like. So I'm interested if there's thoughts about that from anyone.
You mean, Amos, funding for victims of non-licensees?
So it's crime victims, so it is a crime, but there's not a lot of resources for prosecution. And right now, a lot of them are misdemeanors. So I just don't think I would love to see us try to address this or propose something, but I'm not sure what that structure would look like. And certainly we should focus on the other ones, the felonies, the more funding and resources for investigation and prosecution, maybe grant funding, and the statute of limitations.
Ira.
I was disturbed to hear about insurance companies, in other words, bond issuers, resisting payment on the bond and then even going after the claimant on the bond, because the materials that we've seen so far, at least that I've seen so far on bonds, I did some of my own research, made it seem like you make a claim on the bond and there's almost never a problem with the issuer of the bond paying on it. But apparently that's not true at all. And we've been feeling, I think our group has been feeling that a bond is good protection and we don't need to require malpractice insurance. But now I'm starting to doubt that. I was doubting it already because the bond, I think, is obviously it's not real big if there are multiple claimants. Anyway, I'd like to know more about how common it is and that the issue of a bond will resist payment.
Did you have your hand up? Is it an old hand, Amos? Or are you going to speak to this issue?
Just to briefly speak to this issue, because the regulation subcommittee did look extensively at what we called financial responsibility for licensees. So again, this doesn't impact non-licensees, which I think is my biggest focus here. But for licensees, we did look at bonds, malpractice insurance, a restitution fund. Bonds are not perfect. Bonds are insurance companies. They certainly don't pay out for every claim, but having a bond is much better than not having a bond. And so a bond will provide financial responsibility in a lot of cases. Certainly if there's a criminal conviction, that's good evidence, but the bond company, the insurance company, will want some evidence that there was malpractice or fraud or something. So it's not always a slam dunk. Malpractice isn't necessarily easier. Malpractice usually comes with a duty to defend the professional. So malpractice insurance actually includes the hiring an attorney to try to defend against paying the victim. So it's not necessarily better, but usually it's more available. And so I just want to respond that the regulation subcommittee did look at this. I think it's sort of the best solution among the alternatives.
Kim?
Just in response to Amos's question about restitution, I mean, for the Department of Consumer Affairs, this is an issue not, just for this group. We deal with this all the time with unlicensed individuals, and unless you can get restitution as part of a criminal case, those individuals are left to a lawsuit, right, to recoup any costs that they have. So, I mean, I think that's across the board. I think Ms. Jordan had mentioned something about, the state entity. I think it's Victims Comp. I think that's an old name. I think they're like a government control board or something like that now. And maybe we could see exactly what they cover. I'm not sure. I know they do take on other cases other than just like murder and things like that. I've seen a presentation from them. Maybe that's somewhere we can ask Leah them to, let us know what exactly they do cover. But other than that, I think that's the only entity that does any type of restitution like that.
And if I could briefly respond to that as well, that is one of the reasons I think that's exactly right. And that was one of the reasons I raised the question to you and to the discipline subcommittee if restitution was going to be part of the discipline proceedings, because it's not always, or not for all boards, but for some boards it is. And I think that would be a very helpful and meaningful remedy, at least for licensed professionals that are disciplined. That's obviously a subset, but if somebody who a licensed individual who really does some malpractice is required to provide restitution before they can, as a requirement to maintain their license, I think that could be very helpful. And so I encourage the discipline committee to consider that.
Sorry, I was definitely thinking only unlicensed individuals, because you can always add into a disciplinary order. And I don't know, I'd look to Greg as to how we would write that into the guidelines, but you can always add restitution into a disciplinary order that's issued. That's something that was probably easier than the other, definitely.
And you can do so for lawyers now too.
So what do others think about this idea? Amos suggested bifurcating the topic somewhat. I'm not sure I totally get how we would do that between the regulation subcommittee and the discipline subcommittee. Yeah, Greg, go ahead.
Well, I just would make one quick comment, and I also want to thank Ryan and Augustine for a wonderful presentation and great conversation that has ensued. This is a systemic problem with our criminal justice system. When victims of financial crimes, it's very difficult to restore them to a whole position. I think that we should, this is really a legislative issue that needs to be brought forward. And we could do so in the context of UPL, but I think, as Kim suggested, they're struggling with this all over. In terms of the surety bond, I just would remind everyone that we will have a robust disciplinary system behind these paraprofessionals. And so to the extent that a paraprofessional is found to have violated either our rules of professional conduct or any additional statutes that the legislature sees fit to impose upon them, that I would imagine a bond company would pay out if there was such a finding. You don't see that with immigration consultants. There's just not that type of disciplinary system behind them, or unlawful detainer assistance as well. And then one other thing, just to remind everyone, I think the regulation subcommittee also is recommending a client security fund to try to at least partially restore clients if they're victims of wrongful acts of dishonesty by paraprofessionals. So that's an additional provision. And then I think also mandatory fee arbitration.
Okay, well, it's 2:01. I want to be respectful of other folks' time. I also have another meeting to attend. I think we're going to have to figure out next steps a little bit offline, and I imagine it will involve one more meeting of this group. In the interim, I also thank you so much, Ryan and Gus. And one of the immediate things I'll do is circle back around with both of you so we can start getting a written list of your suggestions for circulation to the group. So thank you. I appreciate it very much. Everyone have a great rest of your day.
Thank you. Bye.